All right, so we're playing a little game today called Truth or Myth. Alex, I have a few questions for you today. First question. If you go to work the day after getting into an accident, you're fine and there is no case. Truth or myth?
That is a complete myth. That's something that insurance companies love to focus on. They love to say, yeah, your client went to work the next day. How hurt could he or she be? And that's totally bogus. There are a number of reasons why someone would not go to get treatment right away, why they're not leaving the scene in an ambulance, why they are going to work the next day. That doesn't mean that you don't have a case, and it doesn't mean that you don't have a good case. Context matters when it comes to gaps in treatment. As most people know, you can't call a doctor's office today and get a same day appointment most times. Oftentimes, people need to work. What a wild concept. People need to work to be able to put food on the table. So that's why someone's not going from the scene to the hospital right away. That's why someone is still going to work the next day. Sometimes a lot of people say, hey, you know what? I do feel injured. I do hurt. Let me go home and lay down, take some Advil, take some ibuprofen, and see where I'm at in a few days. Again, context matters. A lot of us have all experienced, viral and bacterial infections. Often it takes days after exposure to feel the full force and to say, hey, something's wrong here. So it's a total myth. It happens all the time. You talk to adjusters all the time who say, your client went to work the next day or they didn't leave an ambulance. So what? Welcome to the working class. Welcome to people who have other values and needs that trump taking care of themselves first. And that's why it's important to make sure that your lawyer, one, tell your lawyer why you had a gap in treatment, and two, let the attorney do the talking. The attorney can put context in, and all of it's true.
Yeah, because I think some people may be afraid to take off of work. They're afraid to use their sick time. They're afraid to call out of work because they're afraid they're going to lose their job. But that's also why it's important for people who are injured to call their attorneys right away after getting hurt. They'll get the right advice.
Yeah. And, just as Melanie said as well, not only are you calling an attorney for help with your case and getting compensated, but even if you're, for example, in a car accident, you get what's called lost wages. We can get your no fault filed, things like that. That's something that an attorney can handle for you. We do the paperwork, we do the investigation while your only job is to get better. Believe it or not, attorneys want you to get better. Okay? We want you to get better, and we want you to make sure you get the care that you need and you take the time off that you need.
And what about injuries that evolve over time? Someone might be in an accident and they are injured, and maybe they didn't need to go in an ambulance that day, but the injury evolved over time. It worsened within a couple of days. Or can you explain that a little bit?
Yeah, absolutely. And that, kind of goes back to an example that we all deal with is, I was exposed to a virus or a bacterial infection days ago, and it stays in your system and you don't really feel it. A lot of times, it is true when you get in a car accident, you are in shock. And not only you mentally, emotionally in shock, but your body's tense, you're in shock. And oftentimes it's when your body starts to relax again and go back to that, normal, regular state that you feel the pain. And a lot of times you can go get imaging done. It doesn't show anything because you're still swollen. A lot of times, if you walk into a hospital and you don't have a broken arm or a broken something obvious, they tell you take a few days, follow up with your general physician, follow up with an orthopedist, and then they can do the right imaging and right testing at the right time to see what's going on. So it can take a number of days or even a few weeks for an injury to really be something that you can find and be developed at that point.
Perfect. I love it. All right. We're still playing a game called Truth or Myth. Alex, I have question number 2 ready for you.
All right.
A good lawyer knows the law. A great lawyer knows the judge. Truth or myth?
I'm going to say this is actually true. But I'm saying it true in a sense that, yes, a great lawyer knows the judge, but I'm not saying wink, wink, nod, nod, here's an envelope full of cash, judge, or I'll see you on the putting green later, Your Honor. What I mean is that every good lawyer knows the law, but every great lawyer does research on the judge because the judge is the very person who's going to issue rulings on this case. So I want to know what the judge thinks. And oftentimes I can look up and use tools to see how, if the judge has been confronted with this issue before that I'm asking them to make a ruling on. And if so, I can let them know they already got it right. Or if I think they got it wrong in the past, I can now present to them and frame it a different way, or present new evidence or new law that they didn't have back then to influence them to change their ruling. I also think a great lawyer will look at what's called the appellate division case law. When a trial judge makes a ruling, that ruling can be appealed up to the appellate division. A lot of judges care about whether they're going to be overturned or not. So what I like to do is say, hey, judge, here's the appellate division stance on it. If you rule this way, they will not overturn you. And that matters to them. That matters to a lot of judges. If I can't find that a judge, he or himself, or she or herself, have issued a ruling on this before, sometimes I know that they're friends with other judges. So I identify the other judge who's in the courtroom next door, and I say, hey, your pal has done the homework. They said this. And oftentimes they want to follow their lead if they trust their colleague. A real life example is I had a particular issue on a case that honestly, I don't want to say we should have lost, but the odds were against us. And I looked up the trial judge who I was going to have oral argument before. I didn't see that she had ruled on the issue before, but her parent, who used to be on the bench as well, had issued the same decision literally decades earlier, and the law had not changed since. So I asked around, made sure they didn't have mommy or daddy issues with their parents, and I presented to the judge the case that their parent had ruled on. And in the courtroom, the judge plugged in the case on the computer and saw the last name and said, wow, you know what? It was in our favor, and it did give her the support to say, I'm not going to get overruled on appeal. And at the end, she said, I came into this, I read your brief at lunch. I thought I already knew the issues. I came into this ready to rule against you, but you convinced me otherwise, and I'll let your boss know. And I said, thanks. And I won. I won on that oral argument. I won that issue. And I think it's because a great lawyer does the extra homework. And another real life example is I had a bench trial before a judge on just damages only. We had already done with liability. And I plugged in the judge. It was in a county I've never been in before. I said, where am I? So I looked up the judge. I had seen a recent article published about the judge. And I saw that in the article, they wanted to put in a note in there that they are a proud grandparent. Outside the courtroom, they're with their grandchildren. And they really put in how much they love their grandchildren. So then I pivot and I turn to my client and I say, we're going to talk about your damages, but I want you to focus on the damages, how this has impacted the relationship with your grandchildren. You can't pick them up from the bus anymore. You can't pick them up off the ground. You can't drive them. You can't take them to soccer. I really want you to focus on that. And then at the end of my presentation, the judge said, I was completely taken, especially by the testimony of plaintiff, about how this has impacted her relationship with her grandchildren, and I'm going to award what counsel has asked. And I got what I wanted, and so did my client. And I think it's because the great lawyer goes and does that extra homework, puts the humanity into it. Anyone can look up the law. It does take skill to apply law to a case, but it also takes that extra skill of making it, putting in that humanity aspect.
Because ultimately the case is assigned to a particular judge. We don't get to pick what judge is assigned to our case. It's the court picks what case what judge is going to be assigned to our cases. So that's why it's important to know the judge, and obviously to be on, do your homework, know what they're like, do that background research. And do you think that applies? Because you were just saying like a lot of oral arguments, bench trials. Is that also, do you do the same? Do you apply the same skills and research when you're doing like a court appearance or motion practice?
Yes, especially motion practice. Motion practice is, I need to make this as easy as possible for the judge. I need to show them that either they have already issued a decision on this issue and it hasn't been overturned on appeal, or I need to show them why they won't be overturned on appeal. You want to make the judge feel safe. It's game, set, match. They're reading thousands of pages a day. Them and their law clerks and law secretaries are reading thousands of pages a day. You got to make it as easy as possible. So one way to do that is to make the judge feel comfortable, or let the law clerk know that they can issue an order with with the judge approving of it, of X, Y, and Z, and they're going to get the full protection of the appellate division. I think it matters a lot, even on a regular appearance. And in particular, there's certain judges where that they need to hear you say X, Y, and Z to be able to now have the authority to give you what you want. So it is very important. You don't just show up and say, hi, I'm the plaintiff and I'm entitled to everything under the sun. No, we're in Erie County Supreme Court. That means I'm in what's called the fourth department. I'm not going to show up and say, Judge, in Queens County, they'll let you do X, Y, and Z. I need to let he or she know I'm in Erie County. You or your colleagues who are sitting on the bench have issued this decision already. Here's why it's right. And here's fourth department case law, because if it gets appealed, it's going up to what's called the fourth department, that says you're allowed to do this and you're not going to be overturned for doing it. So I think, everyone can be a good lawyer. It takes that extra homework to be a great lawyer. And I don't want to get into it, but that's also knowing your jury. I was on a really long trial. That was just delay after delay, and mornings were oral argument, and by the time we got to afternoon, we get like an hour of witness testimony, which just went on forever. And then one of the jurors asked for take a number of days off because their parent died, and some of the attorneys were moaning and groaning about it, like, why are we taking off all this time? I said, I don't mind. I said, I'm asking for money from somebody who cares deeply about their parent. And I'm representing a parent who's very sick and is on death's door. I don't mind if they want to take the time off. That shows to me that I picked the right person. And I don't want to punish them for asking to take time off. If they want to take time off and the judge allows it, I'm fine with it.
Exactly. And then also, just like another aspect of knowing the judge too, it's on the plaintiff's side, we're presenting the case. Like, we have to present the case. We have to prove why we have a case. The other side comes in to defend their case. So I think that's also why it's very important for us to know, like, do our homework, get to know the judge.
Yeah. No, so it's
Yeah.
a truth.
Yeah.
It's a truth. A good lawyer knows the law. A great lawyer knows the judge, not because there's some behind the scenes unethical behavior going on, or backdoor winking and nodding and exchange of money. It's know your audience. And, that's a life lesson, I think, everywhere. Know your audience.
Agreed.
Okay.
All right. We're playing a game of truth or myth still. Alex, I have question number 3 for you. The plaintiff's deposition is just the injured party's chance to tell their story. Truth or myth?
I'm going to say complete myth. I was going to give you the lawyer's answer of it depends, but it really is a myth. It's not your chance to tell a story. A lot of times plaintiffs' firms, or a number of firms or plaintiffs' attorneys, think that the plaintiff's deposition is kind of a throwaway. It is a good learning experience to throw a young associate on, but it is to be taken very seriously. It's not just a time for the plaintiff to tell their story. It's an opportunity for the defense to lock you into that story. And that goes into a whole other topic we can talk about. But it is a myth. It's not just to tell your story. It's not that the defense attorney seems really nice and they're a good guy and all that. That's all intentional. The plaintiff's deposition is where we need to be very careful about what your answers are, because yes, the defense gets to maintain control by asking the questions, but we maintain control by teaching you how to answer those questions. And one way to do that is we particularly like to prep clients at least 2 or 3 times. My goal, and I kind of seem like a pain when I do it, but my goal is that I don't want you sitting at a table with your adversary on the other side hearing a question for the first time. I want you to hear it from me first. I want you to hear the easy questions first, the softball questions, and I want to hear the hard ones. And that way we can manage how you're going to answer these. And when I say manage, you're still answering them truthfully, but we're not telling your life story at deposition, okay? I need you to be focused. I need you to maintain focus on what's being achieved here. It's not just, let me tell you what happened to me. A lot of times you're coming up with a theme. There's a theme, there is a story, there's context to be told. But yeah, it's not just a time for a plaintiff to sit back and have a therapy session. These are very specific and deliberate. And by the way, at the end of your deposition, the attorney for the insurance company is going to write a report that says, "Dear carrier, Melanie was great. Melanie knew how to answer questions. She kept them short and sweet. I think a jury would love her. Let's see if we can put some money on the table." Versus Melanie is easily agitated. She doesn't listen to her attorney. She'll tell you anything you want to hear. And by the way, I would have so much fun having her in front of a jury. I can really get under her skin and make her go off like a firework. A jury will hate her. Let's take this to verdict. All of that matters.
Do you think a plaintiff has a chance to tell their story through their visits with their doctors? Isn't that their chance to tell their story in a sense?
Yes. Oftentimes I have a client who will call me and tell me X, Y, and Z. I still have a lot of pain. I have this fear about what if this happens to me in the future. And I say, that's all true. And that's a legitimate fear or emotion or concern to have. Why don't you voice that to your doctor? Not only so that they can give you the proper care, but so they can document that. Because oftentimes you're also still seeing a doctor after you've been deposed. And unless it's like something major, something new, a second surgery, the defense is not interested in deposing you again. Your medical records will say what they say. If you go to physical therapy or chiropractor, all of that's in there. So that's why it's important that, yes, you can dump that on me, but I can't do much of that for you. My advice is tell your doctor that. And then ask them, make sure I put in my record. I want a record of this. I want a record that this still hurts to this day.
Exactly.
I want a record that, yeah, thank you for the injections. They work for a few weeks. And then after week 3, I'm back at, my regular constant state of pain. This is not working for me. So yeah, I think there's multiple opportunities to tell the story. One is we do want to get the truth out at deposition. We want to manage it carefully. But as you said, another opportunity is you have another professional working with you, and that's your medical doctor. And that's, again, a really good place where you can document your continued story.
Do defense try to get a plaintiff's side of their story by surveilling them?
Yes, that is true. The defense will hire an investigator to follow you to see if you truly are as hurt as you say you are. Well, I should even put it a different way. They want to catch you doing something that you said you can't do. And then they want to use that to show that you're a liar and you have zero credibility and you're not actually injured and you're a total fraud. So it is true. The defense insurance companies will hire someone to follow you to try to tell a different story. And by the way, we've had clients, we get served with surveillance where it looks like they're doing something that they can't possibly be in pain. And guess what? Again, context matters. You have good days, you have bad days. I'm not saying that 2 years after an accident, every day you're stuck in bed. No one is saying that. So if there's a video of you going to Home Depot and not doing anything, picking up a plant, like who cares? That's not, the smoking gun that the defense thinks it is. But yeah, oftentimes, and we do let our clients know, the insurance companies are happy to pay an investigator to follow you from your home to your job, to your doctor's office, to your lawyer's office, especially when they know, hey, I'm going to depose Melanie on the 2nd. Why don't we have an investigator out in front of her house in the morning, see what she's doing, see if she can get in the car and all that, and then go to her deposition. And then let's also have, after Melanie testifies that she can't do any of this stuff anymore, let's see what she does on the way home. Does she stop and go to gymnastics? Does she stop and go to the gym? Is she picking up her kids? Let's catch her in the act of doing something she said she can't do. So yes, I think that's a very good point, that the defense tries to tell a story by hiring an investigator to see what you're doing in real life and what you're doing on social media.
I was just going to say that, like, social media is another interplay with that as well, because sometimes people might post that they were at a party and this gets surveilled, and they might say, oh, they were dancing, but they testify that they're not able to do X, Y, and Z.
Yeah.
So that's another avenue where you can tell your story is on social media.
Yeah.
Or it can go either way. It could go for you or against you.
Or better yet, don't tell your story on social media. Or if you've already told your story on social media, let the attorney know or let the paralegal know, because that drives me absolutely insane. Social media is meant to be like an open diary, not when you have a personal injury lawsuit. Please, I don't even care if you think it's favorable to you. Don't post anything. Obviously, you can't delete anything if you already posted it, but you can make things private. But as Melanie said, if you have a client that says, I can't wear 3-inch heels anymore, and then there's a video of them on a bachelorette doing the Cotton Eye Joe with stilettos on, like, it's not a good look.
Exactly.
So, and again, let your attorney, let your legal team know, because we can manage things like that. We can give you advice. You can't delete anything. You can make it private, or you can be private. But if your cousin or your best friend or your husband or your wife isn't private and they're tagging you and stuff, the defense is still looking. And if I can find it, they can find it. So, and people have been caught that way. And again, it gets managed. But, if a client's sister isn't private and she's posting the same family vacations that would be private on my client, like, it's not helpful. So again, you need to have an attorney who knows all those traps, has the skills to find out what the defense has. We actually have hired an investigator who works for defense companies, and we tell him, do a defense workup on this case. I want to know what the defense knows. Mm-hmm. And then oftentimes, not that I don't trust my clients, but a lot of times people aren't forthcoming or they forget about things. We vet our clients just as well. And I say, it's not that I don't trust you, it's I want to know what the other side knows, and I want to be able to manage it ahead of time.
That's what makes us a good law firm, because we do the work on our clients. We give them every opportunity to tell their side of the story the right way.
Yep. And that's how I hired my stellar paralegal right now. All Sierra had to say to me was that she loves to Nancy Drew cases. And I say the same thing.
You're hired.
I love to Nancy Drew.
Yeah.
You're hired. I already know everything about you. I know about your grandparents. I know when they got here. I know where they live. I know where your kids are. I know what gymnastics they're in. I know everything, okay? Mm-hmm. And also, that's also a test about the attorney-client relationship. If I know something and you're not being forthcoming to me, then we got to work on that.
Exactly. All right. I think that was awesome.